only interact with Spanish, so I've been dealing with a lot of
That's what I look, they see you.
because pretty much every time she translates her video, I have this live translator who has like a whole page worth of like stuff, and I translated a page that I didn't get the copyright, and then we got his copyright, and my attorney was like, "Wait, you don't have to pay this thing, no, living wage, great, we don't send it out to sell stuff." I was like, "I have people my family videos, and you're taking $750 to haircuts, you know?" No, it's not making it for the translation because it's really
Per hour?
to translate that. Yeah. It was only like a 20-minute video, but it was really kind of cool. It wasn't making a capital K, so people have to get
That's true.
yeah.
I'll do it for 700. Because I was, I mean, I'm just Spanish.
They only took it one, they only took it one, but it definitely felt as much as the video was kind of like, it's so good, was like doing it, they never know it.
Well, that,
No, because it even if it's like 30 minutes, if you put in there, and it's like, people have to go.
yeah, I'm not as sharp for that way, like that way. I may used to be. But they, I went to, an interpretive course for the stop at the prison, which is personal interpreter. He actually works to be like basically select people from the person that you're sending for 3 weeks. And it's a, you know, it's be, you have to just use, yes, English, French, Russian, Spanish. I was like, yeah, we had that too, like English, and English, Spanish, you have English, Spanish, and French. Colombia, you have English. Okay, yeah, I'm not gonna do that. Nope, not gonna do that.
And honestly, I opened the interpretation thing, and they were really difficult with the client, for sure what to write it. Like, they would, not just write it, would just be like everything at the same time. And I was like, no, man.
That's where we were doing just thinking, so it's like, we were, when we went through the course, we basically, we got put on a list of military or military persons. Some for the South America, they grabbed for us to one year, the military aspect, and we were included by the language aspect. Or sometimes people be linguists that are like interpreters, but I don't know, but it used to certainly. It comes out like.
I later joined the military
They're not
because
gonna-
I was
like, you know,
23.
you can't have it all about this.
Yeah,
And so I was the one, I was my friends, this is, you're the one record, or Ringo, or, we make different jokes every day.
yeah.
I was actually the first non-native speaker to get through that program. Awesome. And so he was. Every day I got hit. Longer to go. Yeah, Pegasus. But oh, that's Josh. That was a Djibouti for a second. Like, that was the only person who knew about that place. You been there? Yep, I was stationed there for 6 months.
I was like, what's here?
You know, was all over that. YouTube, video. I said, it's not big deal.
Oh my God.
True quality doesn't matter. Like flat, nothing. City or
Station doing like a nice period, not sure.
you never get hit those. Like one of my friends went to, he was in Nairobi. Here's my body. And as I'm landing into Nairobi myself, or that was Ethiopia. I was going in there. It was big, the capital city. And most of the roads were dirt roads. And you get the airport, it's not that either. We go off the airport. And Nairobi airport place. On the way to the airport. Yeah. Wow. We got. Traveling with people, full collar shirt, pants. But if you're stuck in the airport for 15, 20 hours, that may go in there like this, probably not. No AC.
Airline, they do stuff like stuff in terminals for hours. Anyone ever leave the terminal because
Well, the person that, my first time living in Honolulu, I landed there and they segregated me off for like African, they sent me off as one passageway. Okay. And they took me downstairs. They wouldn't let me go back in. As soon as I went through the door, it closed behind me. So I was just going down the stairs. Okay. Maybe it's for the doors there. They sent me out to the damn front. I was stuck. Yeah, with the airplane and the door shut behind me there. You know, like, I'm like, what the hell? So I'm walking along with my bag. How do I get back into this place? And one of the guys was one of the baggage handlers yelling at me. I don't know what you're saying, dude. I have no idea what you're saying. He grabs me with the door, throws me out. I think they're arrested me on the airstream permission.
the weirdest thing. So they just kick you out.
Yeah, they just basically threw me out. It wasn't for the other person paying. I was out there for a good hour. I was just trying to, trying to people. Go to this door. And they stole all my clothes and they kept my bag, double clothes running. And all my clothes, all my uniforms. First time. Yeah. First over. For 3 weeks, I had 2 days. Like the day, for everything, we had washing and water and trees for the military.
Hello. It's a bright light, isn't it?
Yeah, it is.
Gets me in the eyes on a regular basis. Hello.
Are you sure with that? You actually. I'm having questions about the survey. How many people are truly have mental illness? Like, the same issue that they said they're having with surgery?
I've had, so here's the thing. They wasn't sure that I had an assignment, so that's good. So I wasn't held up.
Oh.
And but it's a good one for something.
I know there's some people that need to, I guess, I don't know when the last one's supposed to be done. I did it when I first moved down. If I use Chrome, I work no problem. And I did it when I first time. Like, oh, wait till now. If you wait, then you get have to do one or two, it's like, I don't know, couple of different things.
I didn't know about the game, I just had to walk out. It's a mess. It really is.
I guess I just been. I won't have, don't take when you're at it, like you would start and then stop and that's in. And you just walk.
Well, see, now I'm from private school.
There's not gonna be one time. Okay, I just talked to a few other people. And said, "Oh, I have no notes." So, and that's what I think, I know one of them, I know one person.
Oh my God, I don't know.
So I'm like, so I yeah, I'm sorry. Okay. So we just.
Awesome, congratulations. You what? Really? Let's see, what do you do? Right now, we're working on. It gets frustrating. Oh, yeah. I swear, I think I like doing this stuff, but I think I probably do.
Yeah, we're gonna have these, we're gonna have to help to, and then try to do this, and I hate it, and it's
Not bad.
gives you more opportunity.
That's cool. It's.
Pretty chill. We get around to like,
Yeah.
and then like, we can just have like 30 minutes out of lunch. And you can still.
Pretty cool, that's nice. That's what I'm, where is it?
Oh, it's all in, it's nearly all back here. It's not bad at all. It's not too far, maybe 10 years. Mhm.
Oh, really? Yeah, I want to have this link right there.
But then I told you to go to
Yeah.
Well, he showed me that, and I'm sitting there dying.
Yeah, I
I'm like,
know, that was pretty fun.
I said that to everybody I know. I was like, I don't care if you don't even know the mom, like, you all watched it.
Yeah.
It's really so.
Well, welcome back, everyone. I know some of us are still coming in, but I want to start right on time because if we know anything from past experience of last week and the week before, we only get so many minutes before the big board just goes blank. So I would love to be able to show all of my slides today. So we'll see what we can do and keep that big board going. I always begin every class with a prayer. I thank you for that. You indulge me. and I appreciate it. I guess I'm asking for extra indulgences today because my daughter, I've mentioned Madeline before, 7 years old. She's in elementary school, and she had her famous person speech today, which, of course, thanks to COVID, was to an empty room. It was broadcast here on the internet. So it's a speech all of 45 seconds long, but if you'll indulge me, I'm just so proud of my daughter. She nailed it. There's a dramatic pause there, but I think she intended that. But she nailed it, memorized the whole thing, showed up in costume, did a great job, and actually, I think it's a great way to lead into our opening prayer. So let me hit the button. Check this out. Here she is. I hope the volume's going to be loud enough. This is my Madeline Marie McGinley.
Hi, you know me. I'm Mary, the mother of Jesus. When I was young, I saw a real angel. He said, I would give birth to Jesus. I was scared, but I knew what to say. I said yes. Ever since Jesus was born, I was there by his side. I saw him do miracles, and I saw him forgive sins. I was there at the foot of his cross. Jesus saw me when he said, behold your mother. That's why I'm not just Jesus' mother. I'm your mother too. Pray to me, and I will bring your prayers to Jesus. He will never fail you. He loves you, and I do too.
Isn't she great? I tell you, I'm proud of that girl. She's awesome. Sorry to turn off all the other children. Were there other children in the class? Gosh, who even knows?
And that kid,
No. There you go. My apologies to that child and all the other children. There's more than one person in Madeline's class, but I'm focused on my daughter for obvious reasons. But like her, I'm also focused on who she was standing in there for. I don't know if you could hear the audio, but she said, hi, you know me, I'm Mary, the mother of Jesus. So I've always been a mama's boy. I'm a big fan myself. So, and of what relevance is Mary, the mother of God, to a lawyer? You know, what inspiration can we take there? What guidance can we rise from Mary, the mother of God, a young girl who does such miraculous things for us? And I would say, at the bare minimum, our mother can inspire us by the way she responded. If you could hear the audio, right before the dramatic pause of my daughter's speech, she was explaining how while she was a young girl, she's in persona of the Immaculata there, while she was a young girl, she saw an angel, and she was scared. She was being talked about being the mother of God, but she knew what to say. She said yes. And that's something we can all say to God. We can all say yes. Every lawyer can say yes. We can do what we must, but we can do it to his glory, to God's glory. And at the end of her speech, she mentioned how Mary was there at the foot of your Savior's cross. Can you imagine the pain of watching your son die like that? And my daughter mentioned in the speech, and you see it in the Gospel of John, Christ said, behold your mother. And that's why she's not just Jesus' mother, she's our mother too. You know, if you think about it, she had free will just like you have free will. And she had a mandate. Behold your son. Behold your mother. And she could have just interpreted that to mean what it was on his face. She could have looked at John, the blessed disciple, and said, okay, this one is also my son. But she heard a call from God and she ran with it. She took a simple mandate and made it a more complex and beautiful one from the perspective of service to God and service to our fellow men and women. She made herself, with God's good grace, she accepted the role of your mother and my mother and everyone's mother. And a lawyer can do a similar thing. You've heard a call. Go to law school. You've heard a call. Become an attorney. And you can interpret that in a very simple, one-on-one way. Or you can take that mandate and use it as a call to service. Service to your client, service to your community, service to the legal system. Because after all, if your mother had heard that call, Isn't that what she would have done with it? So with that in mind, our prayer today, in the name of the Father, the Son, the Holy Spirit, amen. Hail Mary, full of grace, the Lord is with thee. Blessed art thou among women. Blessed is the fruit of thy womb, Jesus. Holy Mary, Mother of God, pray for us sinners, now and at the hour of our death. Amen. In the name of the Father, Son, Holy Spirit. Amen. All right, let's hope the big board keeps working. Let's see. We are in our 5th class together, and we will be looking at chapter 5. Chapter 5 takes a more narrow focus than perhaps some of our other chapters did. But we've led into it. We've obtained some knowledge as to how our federal system works when it comes to our national constitution and the subnational constitutions. We've taken a look at the canons of construction and how states' courts can be instructed as to how to interpret the state's constitution. We've looked at the lawyer's role in litigating and therefore yielding court interpretations of the state constitution. And then last week, we looked at the Declaration of Rights, that version of our subnational constitution, which is akin to the Bill of Rights in the federal constitution. We saw certain rights that were lockstep with federal rights. We saw other rights that had taken their own path. Here in chapter 5, we take a closer focus at 2 rights, and we ask that same question: are they lockstep with the federal rights, or has Florida taken its own path? First, we look at due process of law. And what we find there, a lot of words on this particular slide, what we find there is substantive due process and procedural due process under our state constitution are the same rights as provided under the U.S. Constitution. But with that said, I've done my research and I have a hypothesis. I believe there's at least one little narrow window, one little part of due process, which under Florida's Constitution is a greater right than that found under the federal Constitution. Allow me to explain what I mean. You can come to your own conclusion as to whether or not I should label it as a expanded right under the state constitution. Whether or not you agree with that conclusion, it's good to know that this is the current interpretation of Florida's Constitution. Should it come up in your practice? Should it come up for one of your clients? Should it come up on a Florida bar exam? Or should it come up for any other reason? So what we talk about here is under the federal right to due process and comparing it to the state right to due process, we see, or I suggest, there is an expansion under state law when it comes to non-criminal statutes and non-criminal law matters, where something we see exclusively applied to criminal statutes and criminal law matters under the federal Constitution is instead applied to both criminal and all other types of substantive law under the state Constitution. What I'm talking about is the due process clause and a conclusive, or what state of Florida case law often refers to as an irrebuttable. Is that even a real word? Irrebuttable? I don't know. But a conclusive presumption, an irrebuttable presumption. What we find is that in federal law, if you have a criminal statute, that is a statute that yields a criminal penalty that would take away freedom, then an irrebuttable or a conclusive presumption violates the federal right to due process of law. What we find in Florida is, yes, that's true, but in addition, any administrative law statute or civil law statute, or regardless of the type of law, doesn't have to be just criminal. You can't have a conclusive or an irrebuttable presumption survive constitutionality under Florida's Constitution unless it meets the twofold test. And that's what I have here for you up on the big board. The test for constitutionality of statutory presumptions under Florida's Constitution is twofold. First, there must be a rational connection between the fact proved and the ultimate fact presumed. Second, there must be a right to rebut in a fair manner. So a two-pronged test. Let's take a closer look. Prong number one, is this a weighty standard? Is this tough to meet? Is this overly burdensome? I would suggest that the language suggests something akin to a rational relationship test, right? Looks a lot like the rational basis test that we subject the lowest constitutional standard to. And indeed, when it comes to the first prong, we don't have an example in Florida case law where we could point to it and say, oh, look at that. It is a higher standard than rational basis or rational relationship. Perhaps that's what's meant by it. Perhaps as this case law evolves, we might learn that. But as of today, we don't have a site where we could say the first prong is anything more strict, more stringent, or more powerful than a rational relationship test, with which you're already familiar with that legal standard. Looking at the second prong, there must be a right to rebut in a fair manner. And that second prong kind of yields the name, right? It can't be conclusive. It can't be irrebuttable. So it's almost like a one-prong test in practice, but at least in name and definition, the test has two prongs. And we provided an example. And in order to understand that example or any other example, we do have to understand what's meant by a presumption. And what I found is in those instances where there is confusion in the mind of a law student, typically that area of confusion is the difference between an inference and a presumption. An inference and a presumption. Do we understand how those two are different? An inference is a logical conclusion drawn from the evidence. Compare that to a presumption. A presumption is an instruction under the law that a conclusion must exist and therefore is legally established once certain evidence is presented and comes into evidence. That's not a distinction without a difference. That's a very different thing. To help understand that, see if we can conjure some examples. For example, you and I are fighting loudly on the front steps of my house, so loudly that we woke up the neighbors who are now watching us fight. But our fight proceeds to go inside the house. The curtains are drawn. They can't see us anymore. But they hear the fight until they hear the gunshot. Then they see me walking out, holding a gun. That's a smoking gun. The smoke is coming out of the gun. And as the neighbors rush into the house, they find my neighbor who doesn't live there is on the floor bleeding with a bullet in the neighbor. You might reach an inference that I shot my neighbor, would you not? Many juries would. That's not an instance of direct proof. No one saw me pull the trigger. No one saw the bullet fly. No one saw the neighbor land on the ground. But certainly an inference can be drawn. Offering that type of evidence is an inference. Compare that instead to a legal presumption. A legal presumption is something more akin to what you saw in Hall versus Ricci America, which later became Ricci America versus Hall when it reached the Florida Supreme Court. But I included the First District Court of Appeals lower opinion on purpose because it gave us the facts and it spelled out the rationale that I'm trying to teach. The facts of Hall versus Ricci America were roughly as follows. A gentleman is an employee of Ricci America and therefore is covered by workers' compensation for on-the-job injuries. Just such an injury happens. They're doing concrete form work. A co-worker tripped over a steel formwork and jabbed a metal screed into the back of Mr. Astley Hall's head. So did Mr. Astley Hall cause his own injury? No. Certainly not directly. Certainly not from these facts as we know them from the First District Court of Appeals opinion in Hall versus Ricci America. Indeed, at the trial held before a workers' compensation judge of compensation claims, or JCC, the JCC held that this wasn't the injured worker's fault. Nevertheless, the JCC also held that part of the workers' compensation law says that if you test positive for drugs after a workplace accident, then there is a legal presumption that the drugs caused the accident. Mr. Astley Hall tested positive for cannabis or marijuana in the drug test administered when Mr. Hall was taken to the hospital after this workplace accident. And the JCC almost says, and I'm paraphrasing, I'm really sorry here. I understand you didn't cause this accident, and certainly this is covered under workers' compensation, except, and the only reason I'm denying you these benefits is because there's a legal presumption in the law. They offered it to evidence the positive drug test, and you weren't able to keep that drug test out. So now that it's in evidence, I'm sorry, your claims are denied. The holding of Florida's First District Court of Appeal, which was later affirmed by Florida Supreme Court, goes back to this test of due process, and said that the worker wasn't given the second prong, a right to rebut in a fair manner. You have a question?
I'm gonna say, for that guy to even bring that up to be, like, even to appeal it, it seems like, how many people have had that same thing, a very similar situation happen, and they just accepted it? It's like especially construction. I know for a fact there's a whole lot of injuries that happen all the time, and if they just get it denied, there's probably how many other laws that are probably built in like this, and until somebody's brought up the question of, I have no way there's no way to rebut this. So how many people, maybe 1 in 100, that actually decide to fight it, to take it to this, to find out how many other people have been.
It's true. If our elected officials enact a law that is unconstitutional, it is on the books. It is operative. It is enforced until someone makes a finding that it's unconstitutional. And yes, you're right. One could go to court and never challenge the constitutionality of that law or statute or action, and therefore find themselves penalized by it. Yeah, that can happen. And that's how our system is set up, our adversarial system. So we don't have like a screening committee after a law is passed that reviews the law and shoots it down. Or of course, we have to have an actual case or controversy, which is one of the things we studied in chapters 2 and 3. In order to have that, there's the potential for that declaratory judgment or DEC action that we studied. But even then, you have to have the players. You have to have an actual harm. You have to be subject to that law. So yeah.
I was going to say, it's like, it just seems like you can have the law on books and be harming many people for a long time, but until somebody who fits the criteria for this, there's no harm. And basically, you don't even have standing until you as a professor, you can go, that's unconstitutional, but until somebody has been affected by it,
Correct.
You can't even do anything about it.
Correct.
But
Of course, Hall challenged it, and that did something about it.
But he had harm.
Got to have harm. I didn't show all the famous persons, just my daughters. But of course, one of the famous persons is your hero of mine, Rosa Parks, right? And she had to subject herself to the harm in order to get that result. She had to get on that bus in Birmingham, Alabama in the 1950s. She had to get herself arrested. She had to violate that disgusting and unconstitutional and racist and bigoted law. And if she hadn't done that for us, we wouldn't have had that ruling. So yeah, the requirements of standing, the requirements of litigating these statutes often mean that we have to be directly affected by them. You're correct. So Mr. Hall was directly affected. Mr. Hall challenged the constitutionality. The reason that it was unconstitutional is because it failed the second prong. He had no right to rebut, none at all. The JCC almost said, hey, you're entitled to your benefits under this law, except for the presumption. And that led to a reversal. A similar result we see in Castellanos versus Nextdoor Company, which again involves Florida's workers' compensation law. Here, there was a concern about an attorney fee statute. The attorney fee statute litigation was time consuming. It involved much of a JCC's time. Also, it was expensive not only to litigate, but expensive to pay. Under 440.34, the statute within the Florida workers' compensation law that might create fee entitlement, if you obtained a benefit for an injured worker, called a claimant under that statute, if the claimant's attorney prevailed, then the claimant's attorney was entitled to a fee. What the statutory amendments described in Castellanos versus Nextdoor Company tried to do was to streamline the litigation of that by saying, well, whatever that benefit was, your fee is 10%. So if you obtained a $50,000 surgery for the injured worker that had been denied by the workers' compensation carrier and not accepted in time, and you as the claimant's attorney prevailed on that claim, not only would your client get the surgery, but your client wouldn't have to pay you anything, because in addition, the other side, the insurance company, would have to pay a fee, and that fee would be $5,000. What we've had here in Castellanos versus Nextdoor Company, they managed to prove that their fee was below the minimum wage per hour. The judge of compensation claim had made factual findings about what the reasonable amount of time an attorney would have to take to have won that particular claim, doing the strict, conclusive, and irrebuttable presumption that led to an attorney working for less than minimum wage. Now tell me, you all have bachelor's degrees. You all did very well in undergrad. You all could be working in that field. Would you instead like to go through 3 years of law school and pay that tuition and then work for less than minimum wage? How's that sound? Y'all want to sign up for that? No, you don't. Why was it unconstitutional? Again, second prong. There was no right to rebut the presumptive 10%. So what you see here are not two cases involving criminal law or criminal statutes or crimes or anybody getting incarcerated or losing their freedom. What you have here are administrative law actions. So what you have here, I suggest, is a broader right for Floridians under Florida's Constitution than Americans as a whole would have under the U.S. Constitution. That's my hypothesis. The other part of the chapter talks about a right of access to courts. Access to courts. And what are we talking about there? Isn't there a right to walk into a courtroom in the federal system? That's not what we're talking about under state constitutional law when we talk about a right of access to courts. Here we see the right of access to courts as it appears in Florida's Constitution. It's in Article 1, Section 21. So it's in the Declaration of Rights. And this language, if you're a historian, might look familiar to you. Maybe you've seen it before. You didn't see it in the federal Constitution. You saw it in Magna Carta. This language was borrowed from Magna Carta. St. James, Runnymede, all those guys running around there. The court shall be open to every person for redress of any injury, and justice shall be administered without sale, denial, or delay. A lofty goal. But what does it mean? 39 states have incorporated either in whole or in part this type of language originally appearing in Magna Carta. And those 39 states have this right in their constitutions. When it comes to the state of Florida, we have our own interpretation, which is not identical to any other state's constitution and not identical to the interpretation of access to courts found in any other state's constitution. What we have here in Florida is a remedy clause, a right to a remedy. Now, when we look at the language, it doesn't exactly read that way, does it? And indeed, when it comes to the proper interpretation of Article 1, Section 21, the plain text of Article 1, Section 21 doesn't get you to where the case law gets you. These remedy provisions have resulted in a myriad of interpretations by state courts. As I mentioned, Florida's is unique In the last few decades, for example, injured parties have used state remedy provisions to challenge tort reform legislation, to challenge workers' compensation acts, to challenge statutory caps on medical malpractice damages, to challenge existing causes of action and whether or not those existing causes of action can be abolished. Under the federal Constitution, if Congress creates a right to sue, a cause of action, can Congress then later change that right to sue, that cause to action? Almost invariably, the answer is yes. Can Congress even abolish a right to sue or a cause of action created by Congress? Almost invariably, the answer is yes. In either instance, almost invariably, there's not a violation of the federal Constitution to do so. That's the difference between the national and subnational constitutions. In these states, there's a right to a remedy. Once the right is established, after the right is established, the citizens of these states have rights that prevent, either in whole or in part, depending upon the state, the abolition of that created right. That clearly is a state constitutional right that is greater than Americans as a whole have under the full panoply of federal constitutional rights. This clearly is a state expansion. A state constitution's access to courts clause is often at the epicenter of the historic power struggle between legislatures and courts, and what that's referring to is what you may have seen in the news over the years. Sometimes a given state will want malpractice reform. They'll want damages caps. They'll want to limit litigation. They want litigation reform. They want to change the workers' compensation law. They want to change automobile negligence law. Most tort law is of state court origin and state statute and state constitutional law origin. In those states where there's a right to a remedy, those citizens may have certain rights to prevent the wholesale abolition of those existing vested state rights. So this language then is in our Constitution. It creates our open courts clause. It creates our right of access to court. But this is not the legal standard you must know. Instead, what you must know is that it derives its scope and meaning solely from Florida case law. So this is an instance, much like you often saw in Con Law 1 when you studied in the prerequisite class, the federal Constitution. There were constitutional rights that came from the case law. This is such an example when we talk about Florida's access to courts, Florida's right to a remedy. The main or poll star decision is one called Kluger versus White, which is excerpted in your book. And you might be able to read it and distill from it and its progeny what the rule of law is. But also that's my job. So let me teach you the rule of law. Let me teach you what the constitutional right is of access to courts here in the state of Florida. The case law of Kluger versus White and its progeny gives us this test, which I've stated as succinctly as possible. You might paraphrase it yourself later, but I hope you'll agree that I've chosen my words wisely. First, you must know whether or not there is a protected cause of action. Stated somewhat differently, you have to determine whether the state of Florida has created a right to sue or a cause of action that already exists, that exists since 1968. It had to have existed before 1968. Why is this the first prong? Why is this the test? And if you remember your canons of construction, you know the answer. Our Constitution meant and should be interpreted under our canons of construction based on the plain meaning that the state of Florida voters understood those state constitutional words to mean at the time that they voted and made it part of our state constitution. So when we look at Article 1, Section 21, we trace its origin back to the last time that we tore up a constitution and enacted a new one wholesale. That was 1968. So if this cause of action, if this right to sue existed within Florida state law as of 1968, then it's protected by Kluger versus White. The contrary is also true. If it's a newer cause of action, it's not protected. Step one, is it protected? How do we know? We have to ask if it existed prior to the 1968 Constitution. So that's the first element of what we might call a three-pronged test, but there's 2 threes. Bear with me. So prong one, if it existed, then what is the protection? What exactly are we protecting? We're protecting it against being abolished. Abolished. If the cause of action existed before 1968, then abolishing it violates Article 1, Section 21's access to courts as interpreted by Kluger versus White and its progeny. Does that mean I can't change the cause of action? No, you can change the cause of action. Does that mean I can't tweak the cause of action? No, you can tweak the cause of action. Does that mean I can't amend the statute that creates the cause of action? No, you can amend the statute that creates the cause of action. What if I want to erase it, abolish it, do away with it? That's a violation. Unless, that brings us to our two-headed prong 3, unless one of these 2 exceptions apply. Unless there is a reasonable alternative. Remember, when we talk about constitutional law and we see things like reasonable or rational relationship, we're talking about a rather low standard, are we not? So what if I abolish the cause of action and I replace it with one where the plaintiff might recover less money? Generally speaking, that's a reasonable alternative. That meets the exception. And that's not the sole example of a reasonable alternative. Anything that you can convince the presiding courts to be a reasonable alternative will satisfy that test. If you can't satisfy that test, you've got another one. And this is a hard sell. This is highly unlikely, but it exists. So I give it to you as the alternative, number 3. Or unless there's 2 things, both an overpowering public necessity and no alternative method of meeting that public necessity. So if I'm going under the second unless, the second of the 2 possible exceptions, I've got 2 things to prove, right? I've got to prove an overpowering public necessity. That sounds hard. That sounds weighty. That sounds like a difficult burden to meet, and indeed it is. And prove that there's no alternative method of meeting that public necessity. No alternative. So I had to abolish this cause of action because there's a public necessity that is overpowering. And there's just no other way, no alternative method of meeting that overpowering public necessity. So this then is the test of Kluger versus White. Personally, if I was going to practice in the state of Florida, what you do, maybe you will too, I'd memorize it. If I was taking the Florida bar exam, which I did, and I know many of you will too, I would memorize it. I would memorize it just like this. Prong 1, if the cause of action existed prior to 68, then it's a protected cause of action. Protected from what? Prong 2, then abolishing it violates access to courts unless, and this is not a typo, I put 3 twice to emphasize that you don't have to prove both of the exceptions, just one of the 2 exceptions, unless option 1, there's a reasonable alternative, or unless option 2, both an overpowering public necessity and also no alternative method of meeting that public necessity. So that's Kluger versus White. That has appeared on the Florida bar exam on many occasions, and it's certainly part of Florida state common law jurisprudence. But do you understand it? Are you able to apply it? If you were staring at the face of a factual scenario, could you give the right answer? Well, let's find out, shall we? Come on, let's play along. Here's a access to courts hypothetical. I made these facts up. Or did I? Maybe I stole them from case law precedent. But let's take a look at these facts, all right? After successful lobbying financed by Uber. Oh, there's lobbyists involved, huh? After successful lobbying financed by Uber, the Florida legislature enacts a so-called guest statute. We see lobbyists involved in a friendly-sounding law. What's the guest statute do? It protects car drivers from claims of negligence from their passengers. See why Uber might be involved, right? It protects car drivers from claims of negligence from their passengers and guests by requiring the passengers and guests to prove a higher degree of negligence over and above ordinary negligence. So now drivers won't be responsible just for their negligent acts. No. We must go over and above. This guest statute requires the dismissal without recovery of any lawsuit where the passenger or guest cannot prove abnormal and grossly negligent behavior by the driver. Does this violate Florida's access to courts? Who's not going to have access to courts anymore? Most Uber passengers who simply lost their legs or their lives through the negligence of their driver and can't prove abnormal and grossly negligent behavior by the driver. So, who thinks this violates Article 1, Section 21 of Florida's Constitution, or access to courts as interpreted by Kluger versus White and its progeny? Who sees a violation? Raise your hand. No hands are up. I didn't fool anybody. I like that. Yes, this is not a violation. But that's the easy part of the question. Why? Why is this not a violation? Well, here's our test, right? If you want to figure out whether it's a violation, we're going to apply our test. Your hand's up. You want to apply our test. Go ahead. Take us to our test. What's the first thing we do in our test?
Did this exist before 68?
Okay, so we've got a cause of action, right? But it may or may not be protected under Article 1, Section 21 of Florida's Constitution as interpreted by Kluger versus White and its progeny. How do we know whether it's protected?
Was there a law prior to 1968 that allowed not for it?
Did you have the right to sue before 1968? That's right. Were there automobiles before 1968? Who's old enough to remember? I was born in 71. I understand, even though I was only born in 71, that there were automobiles before 1968. And I know that because you see those 50s muscle cars driving down the street. You ever see those? They look cool, right? Yeah. My wife, Bernadette, loves the Mustang. So, but I think the 50s Camaro, the 57 Chevy, a lot of great 50s muscle cars. But I digress. So yes, this cause of action did exist before 68. All right, but we got to apply more of those facts to this standard. What's the next thing we do?
Second prong.
I like that. We go to second prong. Yes.
Is there a reasonable alternative, or unless if there's not?
You jumped. No, the second prong's not looking for a reasonable alternative. The second prong tells us what's protected.
Then it's abolishing the access to courts. If there is a law required, pre-68, does this law abolish that?
Does it abolish this? Take a look at the facts. Have I abolished the Uber passenger's right to sue the Uber driver?
No.
You say no. Who else says no? Raise your hand if you say no, because then you would give the correct answer. Raise your hand and give the correct answer. The correct answer is no. But haven't I made it incredibly harder?
It's still available.
What if after this terrible injury, the witnesses pass away, the victims pass away? They're not going to be able to give me any testimony of abnormal and grossly negligence. It's going to be really, really hard. But it's possible. The cause of action has not been abolished. It's been changed. It's been tweaked. It's been altered. It's been made harder. But it hasn't been abolished. And that's why this is not a violation. Article 1, Section 21's access to courts as interpreted by Kluger versus White and its progeny, Because under Florida law, in this hypothetical, you see that we changed the cause of action but did not abolish it. Excellent. Got one right. Should we play again? Should we play again? Let's play again. Let's look at another factual scenario. Here's hypothetical number 2. In an effort to attract new employers to relocate to Florida, the Florida legislature makes Florida employers immune from lawsuits by employees for injuries arising out of the course and scope of their employment, unless the employee shows that the employer deliberately wanted to cause that particular employee the very type of bodily harm that that particular employee suffered. So in other words, if your employer is trying to kill you, right? Your employer picks up a knife and starts yelling, maybe your name is Joey. Joey, I'm stabbing you with this knife right in the heart. Gonna put this in your heart and kill you, Joey. And then stabs the knife into Joey's heart and kills Joey. That would be an example. That cause of action continues. But what happened to all the other causes of action? What if I'm running after Joey with the knife saying, Joey, I'm going to stab you in the heart, and I trip and the knife lands in Betty's foot? Betty has no cause of action, right? All other claimants are limited to what? We're going to create a list, a statutory schedule, if you will, of benefits. And we're only going to pay under that list, that schedule, a rough percentage of what you would have gotten if you'd sued a tort, or even if you were uninjured and you kept working. Yeah. Let's go with 66 2/3 of your wages, up to 280 weeks. Yeah. Oh, and you go to a doctor too. The employer, they'll pick your doctor. Of course, they'll pick ones that are willing to accept fee schedule, work for the cheapest price. Yeah. And, after they've picked that doctor for a while, and that doctor's not sending people back to work, that doctor will get that doctor off the list. We won't be picking that doctor anymore. All right, well, there you go. What do you think? Do we violate access to courts? Who says yes, it's a violation? Don't say yes. Who says no, it's not a violation? All right, look at that. Y'all got it right again. Didn't fool you, did I? Didn't fool you. What have I described here? Is this a make-believe law? No, this is Florida Statutes Chapter 440. This is our Florida Workers' Compensation Law. There it is. And as its bare bones description here, it's probably also a fair description of many states' workers' compensation law, right? So let's take Florida's standard under Article 1, Section 21, as interpreted by Kluger versus White and his progeny. Let's find out why. Why wasn't that a violation? Did the cause of action exist prior to the 1968 Constitution? Before 1968? Could you sue a tortfeasor, even if that tortfeasor happened to be your employer? In many states, yes. Did we abolish the cause of action? What do you think? Did we abolish it? You're nodding your head yes, and you're right. We did, under these facts, abolish the cause of action.
But we just put all the law in.
No. We said that the employers are immune from lawsuits.
Unless.
Okay, that there was that one particular employee where the employer was yelling his name,
So it just
going to stab him in the heart with a knife, and indeed stabbed him in the heart with a
It wasn't
knife.
completely
Okay.
closed off. It was just blocked. and-
Okay, you might make an argument that we didn't abolish the cause of action. You might make that argument. And if I presented this as an essay, I would really respect that argument. I would. But most folks see this workers' compensation law as an example of a reasonable alternative. Indeed, if you read Kluger versus White, where Kluger versus White says one of the exceptions is a reasonable alternative, what example does Kluger versus White give? The Florida Workers' Compensation Law. So yes, I hear your argument, and I think you could make it. I think you could make it well by applying the correct test. But I'm going to call you wrong for today because Kluger versus White, in the opinion itself, said you were wrong. So if I got binding case law precedent on my side, I'm going to have to go with my opinion. And hey, even if I don't have binding case law precedent, I usually go with my opinion, don't I? So no surprise, I'm going to go with my opinion. But I respect yours, and I can see how you could make the argument. Certainly, cause of action existed. You might argue, but Kluger versus White says that the Florida workers' compensation law does not abolish it. So then, is it a violation? No, because there's more steps to go, right? It met an exception. Even though, green light, yes, we did abolish it, there was a reasonable alternative. There was a reasonable alternative. Now, you might also argue it doesn't sound very reasonable to me. I can't pick my doctor. I only get 66 2/3% of my wages. My wages end at some point, even though my injury doesn't. I got a statutory schedule of benefits that may not accurately reflect my particular economic damages. And don't even get me started on non-economic damages. There's no loss of consortium. There's no pain and suffering. There's no punitive damages. Most non-economic damages, if not all, are eliminated by a state's workers' compensation law. But Kluger versus White gave us this as an example of a reasonable alternative. And since it did, what we should note is what a low standard it is to be a reasonable alternative, right? Reasonable when we see it in a con law context or rational relationship or rational basis is always among the lowest, if not the lowest, standard of constitutionality. And indeed, these facts help to illustrate how low a standard it is to meet this exception. Let's play some more. I see the joy in your faces. You want to play some more. Mike, you got a question. Okay, all right. So you got it right for the wrong reason, but you got it right. So then let's focus on that. Kudos. But the wrong reason part, talk to me.
So, abolishing.
Yeah.
And that's what I'm back up here.
So you don't see it as abolishing.
Right.
And you're not the only student to say that. But Kluger versus White gave us those facts as an example of abolishing.
No, I'm not going to argue with you about that. What I'm saying is, like, so Kluger versus White, are we saying that abolishing something is meeting the standard, or are we saying that abolishing something is we're looking at the point we need to look at?
We're saying it's the standard. Unless it's abolished, we don't have a violation, and we need not seek an exception under the ruling of Kluger versus White and its progeny and the rule of law that arises. That rule of law says if you do something short of abolishing, then you do not violate Article 1, Section 21, access to courts under Florida's Constitution.
So once again, it's a very low standard. for
It is.
abolishing. So if it's like one iota, it hasn't abolished.
That is probably correct. It is a factual question. That's why I say it's probably correct. You might convince one court that it's abolished. You might convince another court that it's short of being abolished. You've got to meet the burden that it has been entirely abolished. The fact that it's been altered is insufficient to meet your burden. The fact that it's been made harder for plaintiffs to prevail is insufficient to meet your burden. The fact that a given plaintiff or the majority of plaintiffs or even all plaintiffs will recover less under the amendment is insufficient to meet your burden. What you have to prove is that they no longer have access to court. They no longer have a cause of action. They have been denied access to court because that access was a cause of action which is now totally gone, which is now abolished. So it is, in that sense, a high standard. Make sense? Okay. And to help it make sense, let's turn to another factual scenario. We're still applying the same rule of Kluger versus White, but let's apply it to this hypothetical. The Florida legislature finds that the following causes of action, existing since Florida's admission to statehood, Hint, hint, that was before 1968. Florida was a state before 1960. I wasn't alive either. So I just wanted to let you know. Florida legislature finds that the following causes of action existed since Florida's admission to statehood, and they have now become an instrument of extortion and blackmail in too many instances. And what are these causes of action? They are alienation of affections, criminal conversation, seduction, and breach of promise. Ladies and gentlemen, what are these causes of action? What are we talking about here? What's that?
Adultery.
Adultery, cheating, home wrecking. Someone took your spouse. Dolly Parton was one of the famous persons of the children who I didn't cover when I focused simply on my daughter. Dolly Parton is not only a famous person, but a great humanitarian and a great songwriter. Ever heard Jolene? Jolene, Jolene, Jolene. Don't take my man. If Jolene takes Dolly's man, does Dolly suffer financial damages? Oh, yes. Yes. Dolly will suffer financial damages. She's going to need to divide up all the possessions, right, between her and her husband. Probably going to need time for that, time out of work, might need assistance for that, might need a judge and some lawyers and some legal fees and some court costs. Some assets might be sold prematurely and they won't ripen into what they could have been. Yeah. Things like alienation of affections, criminal conversation, seduction, and breach of promise do cause economic damages, not to mention pain and suffering and non-economic damages, right? Yes.
What is criminal conversation?
Criminal conversation. Yeah. I know these are all forms of home wrecking, but the actual elements of the now abolished action of criminal conversation, I'm sorry that I can't give them to you with 100%
Because
accuracy.
the other one,
Yeah.
okay, that all spoke of.
Yeah.
of
They're all meant to be along that same
But a criminal
thing that
conversation-
Jolene would do if she took Dolly's man. Yeah. You do know that song, right?
Some of us.
Okay, I'm not a country music fan, but I know it. So I thought maybe it was famous enough to make reference to. Okay, all right. So accordingly, under these facts, these causes of action are hereby abolished and may not be recognized by any court in this state. Does it violate Article 1, Section 21, access to courts as interpreted by Kluger versus White and its progeny? Well, the first thing we know, the cause of action existed prior to 68, right? Because the fact pattern tells us that the following causes of action existing since Florida's admission to state. So we know that, right? Prong 2, was it abolished? Well, again, the fact pattern tells us, accordingly, these causes of action are hereby abolished. Okay, so we can check that box. Sound good? The question then becomes, have I provided you with facts that illustrate either one of these exceptions? I have not provided you with facts that illustrate the first exception. Okay? Although there was an abolishment, there was no creation of a reasonable alternative. There was just nothing. Those facts, however, illustrate this exception. There's both an overpowering public necessity and no alternative method of meeting that public necessity. How do I know that? Because those are the facts of an actual Florida Supreme Court case that says that they meet this exception. As you might imagine, since you've never heard of some of those causes of action, and I couldn't even give you some of the elements of the criminal conversation one, these causes of action are long gone, are they not? Yet this is the only case law example we have in Florida of satisfying the alternative of a overpowering public necessity and no alternative method of meeting that necessity. It's part of the rule. It's the only example I can give you because it's the only example that exists in Florida case law, which I believe proves the following point. That's a very hard exception to meet, right? If all these years and all this litigation, it's only been met once, does that tell you it's easy to meet or hard to meet? I suggest it tells you it's hard to meet. Also suggest this, you're not going to come up with another surefire example of facts that meet this exception, right? That's the only case we can rely upon. This is so much fun. What's that? You want to keep going? Yeah, let's keep going. All right, here's another hypothetical. In 1973, and as you can tell by now, my hypotheticals roughly approximate an actual case. Miami police, intending to use a tear gas bomb, set off a real bomb instead. Oops, right? I think that's the legal term for that factual scenario, right? Oops. Okay. In 1974, a bombing victim sues the city of Miami and others. So there's more than one defendant. In 1975, Florida legislature enacts a brand new law, the UCAT, the Uniform Contribution Among Tortfeasors Act. What's the UCAT say? UCAT says in cases like this, where there's more than one defendant, more than one tortfeasor, all right? This retroactive law, applicable to all suits still pending but not yet decided, says that you can file a motion post-judgment within this same suit to divide up your liabilities if, at the end of the suit, the plaintiff has found more than one defendant to be jointly and severally liable for the same amount. In other words, the defendants can, within that same suit, figure out their contribution. In 1976, remember the suit started in 74, it was still pending in 75. Now in 1976, the plaintiff won just such a judgment. That judgment said that Miami and all the others are jointly and severally liable. Everybody but Miami coughed up some money. And the ones that coughed up some money want Miami to pay its share, so they file a motion for contribution under the Uniform Contribution Among Tortfeasors Act. All right, a lot of complexities going on there. How can we summarize that quickly? We've got a brand new law that is retroactive to a case that existed before the law did, right? And that case refers to a factual scenario that occurred before the law existed. Wait a minute. Don't I have vested rights here? Stated more specifically, do I have a violation of Florida's constitutional right of access to courts as found in Article 1, Section 21, and as interpreted by Kluger versus White and its progeny? Yes or no? If you see a violation, raise your hand. Raise your hand, but not too high because you would be wrong. If you say this is not a violation, raise your hand. Not a violation. Raise your hand with pride because you're correct. You're correct. This is not a violation. How did we get there? This is the case of Village of El Porto versus City of Miami Shores. And yes, it did actually involve a police force that was trying to set off some sort of stun or smoke bomb and set off a real bomb instead. Oops. A retroactive provision of a legislative act is not necessarily invalid. Really? So even in Florida with our Article 1, Section 21, right of access to courts, we can still enact a retroactive law? The answer may be yes. Retrospective or retroactive statutes are only constitutionally defective in those cases wherein vested rights are adversely affected or destroyed, or when a new obligation or duty is created or imposed, or an additional disability is established in connection with transactions or considerations previously had or expiated. Yeah. You ever notice how the Supreme Court of the United States, many of those justices throughout history spoke with such eloquence? For example, Justice Scalia. It's not always true with the state's highest court. This language is a little awkward. It's not quite eloquent. Wouldn't you agree? Thus, the issue in this case is whether UCAT affects vested rights. We hold that it does not. All right. Let's break it down. McGinley, what are we talking about? Breakdown, part one. Can a law be retroactive? Is it per se a violation? Is it always a violation? of Article 1, Section 21's access to courts under Kluger versus White and its progeny for a law to say that it is retroactive? The answer is no. Laws can be retroactive. What rule of thumb do I use to tell whether a retroactive law is unconstitutional? I look under my rule of thumb for vested rights. That's breakdown part 2. Breakdown part 3, what's a vested right? What are we talking about there? A vested right, generally speaking, as a rule of thumb, of course, we can get more complex, right? But generally speaking, as a rule of thumb, is something that's not a procedural right. Well, McGinley, can you be more specific with me? You're defining it in the negative. Yes, because by defining it in the negative, I'm helping to simplify it. You want greater confusion, greater detail, go right ahead and dive in there. But if it's not a point of procedure, then as a rule of thumb, generally speaking, it's not a vested substantive right. Maybe after coronavirus is over, you'll be allowed back into your law library here on campus. Maybe you were blessed enough to have walked in there before they closed it, or maybe you've just seen pictures of a law library on TV. Either way, you may have noticed that when it comes to the reporter system, here in Florida, we use the Southern Reporter or the Southern Third, but there's certainly many other reporters. They line shelf after shelf after shelf, do they not? As we stand here in the year 2021, of course you'll find reported decisions from 2021, but you'll also find them from 2020, 2019, 2018, 2017, 2016, 2015, 2014, 2001, 1997, 1982, 1963, 1954. I've got a library in my office. I have a Southern Second, Volume 1, 1945. Why are they still in your law library? For the most part, they're talking about substantive rulings, right? Now, with that in mind, go look at the statute bookshelf, okay? It's a lot shorter of a shelf, right? You've got maybe the 2021, if it's printed yet, which at this point it's not. The 2020 statute, if you're lucky, maybe 2019 is still on there because I haven't thrown it out yet. If you're really lucky, maybe 2018 and 2017 are still on the shelf. But where's the older statutes? Why are they thrown away? An even better example, go look for rules of court. Ever seen a paperback? It's almost invariably paperback because we're throwing it away in a few months. Rules of court, rules of procedure for how to litigate the case. Where's the 2000 version? Where's the 1987 version? Where's the 1960? They're long into the trash or recycling heap. Why is that? Because nobody cares. When you change the rules of procedure, it applies to the existing and pending litigation. You may have some substantive rights in a statute. So if you've got a really thorough law library, you might have some old ones there. And you certainly have substantive rights in the case law precedent, so those shelves go on and on and on. But if I'm looking for the rules of court from 1972, I'm not going to find them because nobody cares. You can retroactively change that. A retroactive provision of a legislative act is not necessarily invalid. Retroactive statutes are only constitutionally defective in those cases where invested rights are adversely affected or destroyed. Thus, the issue in this case is whether UCAT affects vested rights. We hold that it does not because procedural statutes do not fall within the constitutional prohibition against retroactive legislation, and they may be held immediately applicable even to pending cases. So even in a state like Florida's that has a subnational constitutional right to access to courts, you can still have retroactive legislation, can't you? Answer is yes. But let's put it through the test of Kluger versus White. What you find there, we have under this UCAT case, under this oops, Miami real bomb instead of fake bomb case, We abolished a right, but we created a reasonable alternative. Because you were still in court, maybe the two joint and several tortfeasors couldn't file an independent action anymore, reopen discovery and litigate for years, and therefore, in these facts, it was Miami that wasn't paying. They'd end up paying less because the other side had to do all this litigating. Now you just filed a simple motion in the existing case, but that was your procedural rights that were affected, not your substantive rights. So there was a reasonable alternative. Tough one, but you got it right. How about another tough one? Can you get this one right? Hypothetical number 5. Stay with me. Some of you are still awake, and I appreciate that. For more than 50 years, courts and juries have awarded judgments and damages for invasion of privacy based on false light. Maybe you studied this in torts class, right? A plaintiff wins such a judgment. So he went to court. He survived. Motion to dismiss, motion for summary judgment, and he won. Then the loser appealed. And the appellate court, the District Court of Appeal, affirmed. Then the loser sought review in Florida Supreme Court. Nobody's saying that the cause of action doesn't exist. But Florida Supreme Court decides on its own accord to say, hey, all these years of litigating false light, which you can find in the Restatement of Torts and in so many other states, surprise, that doesn't even exist here in Florida. On these grounds, we're going to quash your judgment, even though that wasn't an issue anybody ever raised in this suit. What? Have I finally given an example of violation of access to courts under Kluger versus Wright? Raise your hand if you see a violation of access to courts under Kluger versus Wright. Either you're asleep or you're absolutely correct for not raising your hands. Because yet again, this is not a violation of Article 1, Section 21's access to courts under Kluger versus White and its progeny. Why is that? To get the answer, we always apply the same test, do we not? What we find here, the cause of action had to exist prior to the 68 Constitution. What Florida Supreme Court said is that this cause of action never really existed in Florida. Sure, the academics were talking about it in the Restatement of Torts. Maybe even the law schools were teaching it because it was in the Restatement of Torts. Maybe even courts assumed it was part of Florida law because it's part of the law of so many states. But surprise, it never really existed. So if it never really existed, do I have to prove that what's going on here is an abolishment? No. Is it enough to prove either this exception or that exception? No. Because the cause of action, the right to sue, is not protected under Article 1, Section 21, unless it existed prior to 68. So there are classes of causes of action, at least two classes. There's that class that existed before 68. That's the protected class. There's all those other causes of action that didn't exist before 68. They are of an unprotected class when it comes to access to courts under Article 1, Section 21 as interpreted by Kluger versus White and its progeny. That's what that hypothetical attempts to illustrate. You want more? You got it. You got more. Hypothetical number 6. Mr. Sibley, if you read the chapter, you certainly encountered the case of Mr. and Mrs. Sibley, did you not? Mr. Sibley is duly licensed to practice law in Florida. He represents himself in his divorce from Mrs. Sibley. And apparently in so doing forgot that he must have once loved her, right? Because when he loses the 28th case between them, Mrs. Sibley alleges that that case and most of the other 27 cases were frivolous. So she asked the appellate court to bar Mr. Sibley from representing himself in court in future proceedings between them. He is licensed to practice law. In addition, he's a litigant. If you're licensed to practice law, you have a right to do what? Access the courts, right? If you're a litigant, even if you're pro se, even if you represent yourself, even if you're a litigant who's not a lawyer, if you're the litigant, you've got a right to do what? Access the courts, right? But here, Florida's 3rd District Court of Appeal grants Mrs. Sibley's motion. He literally can no longer access the courts, Mr. Sibley. So here we go. I've given you facts where literally someone can't access the courts. Raise your hand now if you think there's a violation of access to courts. Come on, we got a guy who can't access the courts. Did we violate access to courts? Raise your hand. Why is no one raising their hand? No one's raising their hand. The reason no one's raising their hand is because these facts are not illustrating a violation of access to courts. And if you don't believe me, it's in the book, right? If you read this chapter, you read this case. What paper page am I on? If you bought the paper version, I'm on page 170, but it keeps going. 173, 174, 175. Do you notice the appendix? Look at all these cases. When he loses, he appeals. When he loses the appeal, he appeals from that loss. He also sues the judges. Did you notice the judges who rule against him get sued by Mr. Sibley? I mean, 28 cases, but yet not an violation of access to courts. Why is that? Didn't Article 1, Section 21 talk about having access to the courts? Yeah, but that's not the legal standard. Remember the forewarning? This was an example of a constitutional right where the case law precedent, specifically Kluger versus White and its progeny, has created a right, the language of which is not reflected in the plain text of Florida's Constitution. These words don't appear in the plain text of Florida's Constitution, but I hope you'll agree that these words are an accurate description of the legal standard. So here, what we had is not a violation because it passes the test. Does Mr. Sibley, and he may still be Attorney Sibley, I don't know, I haven't looked it up, but does Mr. Sibley have a reasonable alternative? Yeah, he can do what? He can hire an attorney, or can he? An attorney has to abide by the rules regulating the bar. If there's a frivolous suit, it's an ethical violation. It violates the rules regulating the bar to bring a frivolous suit. So some of these things, like when he loses the appeal from the appeal and then wants to sue the appellate judge for having ruled against him, he may not find a lawyer who's willing to sacrifice her or his bar license by signing off on that suit, right? Yes, well said. It is a gatekeeping role. Well said. So I would suggest it meets this one. Who knows? Maybe it even meets that one. We've only got one case law example where it meets that. But I hope that I've illustrated here and in the text a literal physical inability to access the court. But that doesn't meet the standard of a violation of access to courts. So when we look at our open courts clauses, such as Article 1, Section 21, we're not talking about a state law equivalence like the Americans with Disabilities Act or physical access to courts. That's not what we're talking about. You understood that already, right? I tried to illustrate that with these facts. Hypothetical number 7. You can't get enough. That's okay. I shall satisfy. Hypothetical number 7. Let's take a look. The Florida legislature enacts a law providing that an action founded on the design, planning, or construction of an improvement to real property must be brought against the professional engineer, registered architect, or licensed contractor within 12 years after construction of the improvement. Does this violate access to courts? Interesting. I literally am preventing litigants from going to court if they don't get there by a deadline. Can there be deadlines for going to court? You say yes, you say yes, you say yes. Everyone says yes. Good. Didn't fool anybody. Sure. Can you think of the names of some deadlines? Limitations, yes, statute of limitations. Repose, statute of repose, sure. Yes. Latches, yes, yes. All right. So in a state like ours that has an access to courts clause in its state constitution, can you still have deadlines such as statute of limitations, statutes of repose, latches? Can you still have such deadlines? The answer is yes. Here, we know that the cause of action existed. Abolishing it would be a violation. But assuming you meet the deadline, there's a reasonable alternative, right? You can still go to court. The abolition of your particular cause of action is within your own hands, is it not? Now, going a little bit afield, going a little bit away now from the rule of law and to some of the issues involved, we sometimes find it troubling in society to say that there should be a deadline, a limitation, right? In most states, most times, murder, for example, there's no statute of limitations for it. And as we evolve, we're starting to ask ourselves, are there other causes of action that perhaps shouldn't have a statute of limitations involved? And certainly those are public policy questions that can be answered by a legislature, even a legislature in a state such as ours, where the subnational constitution includes an access to courts clause. Because there, you're not required to have a statute of limitations, right? Something to think about. Let's look at hypothetical number 8. I know what you're saying. McGinley, is this the last one? Yes. Yes, it is. It's the last one. We're almost at the last one. And you know, the computer hasn't cut out. My theory was it's going to cut out. I'll just keep going until it cuts out. These computers, they must know what I'm thinking, right? So here we are. It's 7 p.m. already, hour and 45 minutes without a break. Sorry about that. But I presumed we'd take our break when the computer went blank. That's what we did the last 2 weeks in a row. Sorry about that. Bear with me, though. Bear with me. Your patience shall be rewarded with an early exit. Sound good? All right. Anybody who doesn't want to leave early is welcome to stay. I'll be here with you. Okay. Hypothetical number 8. Let's take a look at these facts. The Florida legislature enacts a 12-year statute of limitations for harm arising from ingesting faulty prescription medications. And again, I borrow from actual case law precedent. So if these facts hit too close to home, I apologize for that because they're real. 20 years after the prescription drug DES is removed from the market, science learns that women whose mothers took DES while pregnant have a significantly higher chance of cancer. So did the woman ever take DES? Well, not willingly, not on her own volition. While she was still in the womb, her mother took DES. And in that way, the woman took DES. We didn't know 20 years ago when mom took DES that it would affect the baby. But now, 20 years later, the baby is affected by the DES. One such affected woman, her suit against the drug manufacturer was brought as soon as possible because not only did the woman not know of a significantly higher risk of cancer because while she was still in the womb, she received DES through her mother. Science didn't know either. Courts didn't know. Manufacturer didn't know. Drug companies didn't know. Pharmacy didn't know. Doctors didn't know. Regulators didn't know. 20 years later, with 2020 hindsight, we know, but nobody knew. Now, there was a 12-year statute of limitation. So her suit is dismissed under that 12-year statute of limitations. Did I finally illustrate a violation? of access to court under Florida's Constitution as it appears in Article 1, Section 21, and as it's interpreted by Kluger versus White and its progeny? And the answer is, yes, I finally did, but only as applied, not on its face. Only as applied, not on its face. I hearken you back to a previous chapter, specifically that chapter of our text, our second or third lecture, where we talked about the pleading requirements of alleging a constitutional violation. Within those pleading requirements, if you read the chapter, you already know you have to choose whether you're going to assert it's unconstitutional on its face or it's unconstitutional as applied. And in Florida, since we can plead in the alternative, a third choice would be to allege both. A fourth choice would not be to allege neither. I've seen litigants not know that they had to allege either one. And I felt bad for them as they stood in oral argument in front of appellate court. And the judge says, it sounds like you're arguing this as applied or as you're arguing on its face. And the face of the attorney looked puzzled because they didn't know that they were supposed to argue one or the other. You should know. I'm telling you now. And it's in the text. Now, what's the difference to allege that it's a violation on its face versus a violation as applied? A statute or law that is a violation of a constitutional right on its face violates the rights of everyone, everywhere, under every factual scenario. The plain language on its face shows a violation of the Constitution. Compare that to alleging that the statute is a violation as applied. What does that mean? When we allege an as applied violation, we are saying that for our particular client, and if you want to be a little more broad, you can say, and those similarly situated to our client, but you need not even go that broad. For our particular client, under our client's particular facts, this law violates our client's constitutional right, even if it doesn't violate the constitutional right of other folks who are not similarly situated. Compare those two choices of litigation. If you're the plaintiff and making that choice, you might say that you'll set the defense. What do I mean by set the defense? Well, if you choose to argue that the statute is a violation on its face, then how might the defense overcome your argument? They might overcome it with a single instance of an individual or organization who is subject to that law or act or action and who suffers no detriment and who does not suffer a violation of a constitutional right. If I, as the plaintiff, have alleged is unconstitutional on its face, I might put on 90 days of trial with sympathetic after sympathetic victim and witness. And then after I rest my case, the defense puts on a single witness who is equally affected by and applied this law to them, but has not suffered a violation of constitutional rights. In that hypothetical case, who has won? The defense has won because I have not met my burden of proving a violation on its face. Compare that choice of litigation to as applied. Under as applied, I'm saying that for my particular client, and if I want to be a little bit more broad, I could say, and those similarly situated, there's a constitutional violation. So I put my client on the stand and I prove the constitutional violation. Then I rest my case. Then the defense puts on 90 days of witness after witness after witness, all of whom had this same government law or action applied to them, none of whom suffered any violation of any constitutional right. Has the defense won that case? No. So I've proven my case. So you see the litigation difference. Obviously, it's harder to prove on its face. Why then might I argue something to be unconstitutional on its face? because the remedy is different. What if I win the litigation where I alleged it was unconstitutional on its face? Then the result of my case is that that law can no longer be applied to anyone. It's almost as if I have stricken the law from the books, which is just a figurative term because no one's going to head over to your law library with a big eraser and erase it off the books. Heck, thanks to COVID, no one can walk in there anyway, right? But even if they could walk in there, they would. Figuratively speaking, the remedy is that I've erased the law from the books, because if I've proven it's unconstitutional on its face, then the result of my particular litigation means that you can't apply that law to anyone anymore. Compare that to the remedy available if I argue that it's unconstitutional as applied. What I find is that I now have a remedy that is applied to my particular client. Others might be able to come forward, and those others might be able to prove in their own litigation that they've met their burden to prove that they are similarly situated, and therefore might use my outcome as case law precedent to obtain the same outcome I did, but they're going to have to do that by raising the claim and litigating it. I haven't even figuratively stricken the law from the books if I've proven that it is unconstitutional as applied. I've obtained a judgment that protects my client, and through full faith and credit will protect her wherever she goes in this great nation of ours, but it's not going to protect anybody else who doesn't meet their burden to prove that they're similarly situated. So the remedy is different. Certainly there are more distinguishing characteristics to on its face versus as applied. I encourage you to read that part of chapter 2 if you have not. But I have to bring it up here so that you can understand that all I've done here is proven a violation of Article 1, Section 21's access to courts as interpreted by Kluger versus White and his progeny as applied to this particular DES victim. This particular DES victim, to her, I have proven that as applied, this 12-year statute of limitations violates Article 1, Section 21's access to courts. Sermon's cause of action, and as you've guessed, yet again draw from actual case law precedent, the case at the top there, Overland Construction versus Sermon's, 369, 7th, 572. Sermon's cause of action was already barred by the 12-year limitation when it first accrued. That is, when his injuries occurred, no judicial forum would ever have been available to Sermon's if the 12-year prohibitory portion of the statute will give it effect. The application of this purported limitation statute destroys a cause of action before it legally exists. The statute of repose may be valid under state or federal due process or equal protection clauses, but it violates Article 1, Section 21 of the Constitution. Look at that. Did the U.S. Constitution provide this result? No. Did the full panoply of federal rights provide this result? No. Only the subnational Constitution, only Florida's Constitution's right of access to courts under Article 1, Section 21 provided this result, and only as applied. 3 important points to take from this quoted portion of the opinion. Know the difference between a statute of limitation and a statute of repose. Second, it is unconstitutional as applied, but not on its face. Third, bringing of an action here is abolished, not shortened. Abolished. As applied, it was abolished. Now, let me digress a little bit. This is hypothetical number 8. But hypothetical number 2, I was getting some resistance, and I respected it because I was being told that hypothetical number 2, which was a rough summary of Florida's workers' compensation law, wasn't necessarily abolished. It wasn't a reasonable alternative. I relied upon Kluger versus White, which tells me that it is a reasonable alternative. Certainly, I can rely upon Kluger versus White on its face. But what if, my well-respected resistors, what if you actually were workers' compensation lawyers with workers' compensation clients? You might consider bringing in Article 1, Section 21 access to courts challenge, not on its face, because Florida's workers' compensation law has withstood that challenge on its face time and time and time again through the decades. But you might be successful in bringing such a challenge as applied. Perhaps. Got to be a good litigator, but maybe you can do it. My point is this, and this brings us back to hypothetical number 8. Even if it's constitutional on its face, it might still be unconstitutional as applied to a given individual under that given individual's very specific facts. And what we see here in this hypothetical 8 is exactly such an outcome. Sermon's cause of action is okay, I think we did that slide already. Oh, I put pretty colors on it. I put pretty colors on the slide. Everybody likes pretty colors when they're awake. They're not as entertaining when we've been going for nearly 2 hours without a break. Okay, more pretty colors. What are those pretty? Do you know this rule of law yet? I respectfully suggest that if you choose not to memorize it, you come up with your own language and learn that. Because if you want to know what this rule of law is, it's not going to be enough to just open the text of the Constitution and read Article 1, Section 21, right? More pretty colors. Okay. Wow, that's a dense slide. What do you think? Dense slides, or should we get out of here? I vote for out of here. All right. I guess if we factor in the break, I still might be leaving 5 or 6 minutes early. So at some point, we're going to have to go 5 or 6 minutes late to make up for that lost time. But you've got a question, and I'll subtract off the 5 or 6 minutes as I answer the question. So now we're down to 5 minutes. Go ahead. 4 minutes. Just kidding.
On the website for slides,
Yeah.
week 4 and this week are not available yet? Or did you
Yeah,
say-
they're always available after. So you don't look there for the slides before I present them.
Right.
You'll see them after.
But-
And for that reason, some of these slides I never got to present. So I'm not going to put the unpresented ones up there. So I'm missing maybe 5 or 6 slides from last week before the computer crashed. I will get those up there. I will. Sorry for the delay.
Okay, I was just wondering how long it would be for.
I like to do it within 48 hours, but as you can see, I didn't meet my self-imposed deadline last week. I apologize for that. I hope it didn't inconvenience you. I'll do my best to meet that deadline from now on. So first time I missed it this semester, I'll make it the last. Yeah. Any other questions? Okay, I'm letting you out 3 minutes early. Sorry about that. Oh yeah, there you go.
I'm sorry. I don't think you already stated this, about our midterm exam
Yeah, the midterm. When is that?
in 2 weeks.
Is it?
I think it's.
I better write one.
I think it's the 23rd.
You don't have to.
I don't have to. No, I literally have to. I literally have to. It was in the job description. I have to give a midterm, a final, and a graded project in between. It was literally in the job description. Yeah, it wasn't my idea. Don't blame me.
I believe it's the 23rd, and I just didn't know like I didn't catch it. It just said when you wanted to, how you wanted to.
Yeah. Again, that's in the job description. I have to use something called Canvas.
Is it that kind of stuff?
Yeah, I have to use something called Canvas. I got to upload it to there. So I've used other quiz making software in the past, and boy, it was a lot better than Canvas. But it's in the job description, so I'm going to use Canvas. Yes.
Open professor, open book.
No, nothing's open except your mind. You want to be open-minded. It is not an open book test. It is not open. I think when you run the Canvas, it in turn runs something called Lockdown Browser, right? So even if you wanted to look something up on the internet, you're not going to be able to. At least that's the theory. But please don't. We have our own honor code. So know that it's a closed book test, and you should not be looking at the book while you're taking the test. You should not be looking at the internet. You should not be looking at anything other than your vivid memory of these laws and rules that I've shared with you. Question.
Will this be a multiple choice exam?
Oh, yeah. Yeah. Again, that was in the job description. So I used to pride myself in never giving a multiple choice exam. Yeah. But as a man who preaches the doctrine of subsidiarity, I have to respect the managers who tell me that I have to do certain things. And that's one of the things I have to do. I have to give you a multiple choice exam. So be it. Wouldn't have been what I chose, but I respect their authority. So that's what I'll do. Yeah. Before I let you out 20 seconds early, yes,
Is it just multiple choice? So that's it? Like,
on the midterm.
Oh, okay.
Yeah.
Okay, yeah.
Again, wasn't me. If you love it, then I'll take credit. But if you hate it, it wasn't me.
You know how many questions by chance?
Oh, I haven't even read it yet. So, I mean, I haven't written it yet. So I can't read the questions to you. Yeah, but you're not getting the questions in advance. Is that what you're asking? You want the test questions in
I'm asking
advance?
How many questions?
Now, with that said, if I ask the question in class out loud on the slide in the book, they're fair game. I can copy and paste just like the best of us. Yeah,
If we don't ask, we never know.
there you go. Yeah,
What's worse can say?
yeah, ain't so bad. All right. Well, I've kept you to the required amount of time, so no need to add extra minutes to another lecture. But I do apologize for the no break. Honestly, I didn't think the slides were going to go the distance, and I thought that would be our break time. So if you've got dry mouth and are thirsty, just imagine I am with you on that. Yeah. All right. Until next week, may God continue to bless us all. Thank you again for putting up with me. I hope I'm serving you well. Good night. Thanks.
Good night, Professor.
Yeah, have a good one. Hey, the computer just crashed. I knew it was going to happen.
We did not go early. We did not go early. We're taking our break.
We're taking our break. The computer crashed. Back for a break. I knew it was going to happen. I knew. Unbelievable.
The way my day we go on knowledge class,
Yeah, you told me. I really crashed into it.
everything. Every time, like, but when I was at a school in the military, I was doing anything outside of what they told me to do. Every day, not one day, I would have everything inside. I spent 2 weeks at the school, taking everything, like, reading everything, and not one day that I go to the, not one day.
Talk about a productivity killer. Man, how do you get anything done like that?
But there's always supposed to be a 1 week class, and then I get, then extended.
My other one.
And it's like, the next week, nothing happens, like, you know what? We know what's going on. And they sat there and watched, I had somebody holding my shoulder to make sure I wasn't sabotaging the computer. They found out there was something wrong with the computer on a different end. They brought it on this technician, but I was like, for 2 weeks, I was sitting there like, you get paid to sit here. You get paid for stuff.
Oh, sorry, okay.
It's really not.
Right?
It's really not.
I know I was just joking around. Please don't understand that. I'm not trying to do this like that. It was that.
No, it's cool. Yeah, those are good questions.
I did send that to one
So
of
the
my.
midterm's only 2 weeks away, huh? But
Yeah, I
yeah,
just,
now's the time to write.
you kind of hit me.
If anyone has suggested any questions for the midterm, just email them to me. I'll copy and paste. Yeah, oh, well, yeah, don't send me the question without the answer. What if I get the question wrong?
Or you can always, we can always review it.
Okay.
But,
I gotta shut this computer off. I'll see you on the other side.